Welcome everyone. I'm Bill Rogers. I'm an associate family lawyer at Russell Alexander Collaborative Family Lawyers. We help families with separation and divorce. We upload videos about current family law cases and other interesting aspects of family law. So without further ado, let's get into today's topic. In a judge's ruling and reasons, how little is enough? If you are a family law litigant who's had his or her day in court, you expect to receive a clear ruling from the judge who's presiding over your case. And that ruling should not only state an incisive decision one way or the other on each of the contentious issues, but should also give fulsome reasons for why the case turned out the way it did. But what if the judge's reasons happen to be on the brief side? How little is enough? And when are a judge's reasons considered to be so unacceptably sparse or vague that they are legally inadequate to do justice to the case? This question was the recent focus of the Ontario Court of Appeal in a case called Champeau and Jefremova, where the court introduced the topic this way. The law regarding insufficient reasons is well established. Reasons serve many functions. They justify and explain the result, tell the losing party why they lost, provide public accountability, and satisfy the public that justice has been done and is seen to have been done. And they permit effective appellate review. And the court added that if a judge's reasons do not fulfill these functions, then, in order to protect the judicial system's integrity, it may be necessary to send the matter back for a new hearing. That can become a waste of judicial resources as well as a waste of time for both the judge and the parties involved. If you're enjoying this video and find it helpful, please give it a thumbs up and leave your thoughts in the comments below. The other challenge arises on appeal. If the trial judge's ruling fails to provide insight on how he or she reached the legal conclusions and omits identifying the facts that were relied upon in reaching them, there can be no meaningful review by an appeal court if that later becomes necessary. And this being the case, a trial judge must do more than merely recite the facts of a case and give a conclusion. Rather, there must also be a considered analysis of the issues. Otherwise, the parties will be left to speculate on how the judge reached his or her decision on a critical aspect of the case. And after looking at the trial judge's reasons in Champeau versus Jefremova, the appeal court agreed with one of the affected parties who had complained that she did not understand the logic behind the judge's dismissal of her claim. Indeed, the judge had failed to mention the reasoning behind the ruling on certain key issues, which left the reasons, quote, not amenable to appellate review. And the appeal court added, understandably, Ms. Champeau complains that the trial judge failed to engage with the crux of the case before him, and accordingly, she's unable to understand why her claim was dismissed. And the court was left in the dark about how the trial judge dealt with these critical issues, and for this reason, the judge ordered a new trial. To learn more about this case, you can read the full article linked in the description below. If you like this video and found it helpful, please give it a thumbs up to let us know. You can also leave your thoughts on this case in the comments below. And please subscribe to our channel and hit the bell icon to get a notification every time we upload a new video. Thank you for watching.